Court does call the case. People versus Anthony Williams.
Caitlin Kirby on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Williams.
Mr. Williams, can you state your name, please, sir?
Anthony Williams.
All right, what are we doing?
Your Honor, I would like to request an adjournment of the pretrial. In addition to that, I did submit a motion to change some of the phrasing that was in his bond violation sentence so he can get assessed for treatment at the jail. And if I may provide a little background, Your Honor, I can do so.
I don't, so I just need it changed from may. My language is the court will consider release to inpatient treatment. You need that changed to the court may release?
Correct. So I spoke with the social workers in my office and they spoke to the jail. The jail will not consider defendants for treatment. If it's a consider, it must be a may be released to treatment.
What the heck? Who said that?
That is what our social worker team and the person who works for Access, who does the treatment evaluation, stated to our office.
So the fact that I may consider it or that I don't consider it. Seriously?
Right.
Sir, can I
want a name. Because somebody's going to argue language with me?
Apparently the person at the jail who does it is Brad, my social worker told me. I frankly don't know who Brad is.
Is he a lawyer?
I have also heard this from Sarah Stewart.
I don't know if it's a resource thing at the jail, or what. But
that's okay. I'll go down and talk to Brad about linguistics in a moment. I will change that to defendant may be released to inpatient treatment. And then you need this adjourned out?
yes, please, Your Honor.
Pre-trial will be adjourned October 18, 2023 at 9 a.m. I guess I don't have to consider it anymore. All right. Thank you.
Thank you, Your Honor.
Thank you, Mr. Williams.
so what's going on? I don't
Pardon?
I said what's going on? I don't know what's going on.
All right. We adjourned it out. Apparently they didn't like the language I had. So what I did, hang on, something happened to my screen there. All right. So what I did is I changed the language to something more acceptable. So hopefully you can get inpatient treatment.
So I will not be
okay.
So I won't be getting
Pardon?
out. So I won't be getting out today?
Not today. But hopefully my change in language will get you moving in that direction. Okay, thank you. Court calls the case, People versus Aaron Porter.
Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Michael Vincent on behalf of Aaron Porter. Mr. Porter, check in, state your name for the judge.
This is Aaron Porter.
All right, very good. All right, we have him there. Okay, what are we doing?
Your Honor, I would like another adjourned pretrial. Hopefully we'll be able to work something out with the prosecutor's office, whoever is going to take over this case.
We have a couple of problems. I don't mind giving you the adjournment. However, Mr. Porter has a bond violation.
That is correct, Your Honor.
There are a number of missed tests, but outside of his missed test on the 2nd. He tested positive for alcohol and didn't do his retest. What does he want to do?
Beg for mercy.
Pardon?
Beg for mercy. Mr. Porter.
Does he admit to the violation? Because he
Porter,
initially indicates to community corrections he didn't consume alcohol.
he has informed me, Your Honor, that just prior to the test, apparently he used Listerine. Now, if the Listerine was
Okay, all right. So how much
Yes.
Listerine did he use? Before Mr. Vincent, you go ahead with this argument. He was a 0.14.
I have the report in front of me, Your Honor.
Yeah, I know. That's a lot of Listerine.
Well, if I may respond briefly.
Okay, go for it. I'm anticipating. I'm sitting here in breathless anticipation.
I'll go fast then.
Okay, go for it.
When I went to breathalyzer school, one of the things I was trained to do is wait, if somebody had alcohol in their mouth, wait 15 minutes before you test. Why? Because even though the alcohol may have been swallowed, it'll still be in his mouth, which will give you a high, sometimes a very high breathalyzer reading. The only explanation I can give this court is that he must have washed his mouth off with Listerine and then immediately did the test. I did some math. He tested at 7 p.m. Excuse me. He had the times just really don't add up as far as elimination, because on 12:50 he tested 0, and you lose 0.015 an hour. If that 0.14 was accurate, he should have been at 0.06 at that time, assuming a 0.015 elimination rate, which everyone has the same elimination rate. So that is my argument. I'm going to talk with my client.
Does he want a hearing?
I think, what do I think?
Hold it, Mr. Vincent. I'll
Yeah.
have a hearing on it, but he tested positive and then missed this next 6 retests.
And Your Honor, regardless of the elimination rates, I appreciate Mr. Vincent's argument, but Mr. Porter signed a form that every person who gets a sober link signs at community corrections. They initial their initials next to each line. One of the lines, I think it's line 4 or 5, says that you may not consume anything with alcohol in it. And that includes NyQuil and Listerine. So regardless, it's a violation, even if it was a 0.01. So if he's sticking to the Listerine story, it's still a violation.
That's also true.
Your Honor, could we try a scram tether on him?
And
And
I will admit to the
down-
violation.
Yeah, and I will. Well, he clearly violated the don't drink Listerine, don't use Listerine. I mean, that's clear. I would like for him. He works as a medical assistant at U of M. I'm familiar with the procedure at U of M. If they think you got any kind of substance in you that you shouldn't have, they'll send security up there. You'll be checked out. Perhaps a scram tether would work better on him, and I will have him in my office, and I will enunciate, stay the hell away from Listerine and NyQuil and all the other stuff.
So I'll indicate in here that the defendant admits to a violation. Defendant is to be switched to a scram tether. He must report within 24 hours of today to be fitted with that. I'll then adjourn this matter to October 18th, 2023, 9 a.m. I should also place on the record that the defendant was also given the opportunity to come in and submit to an ETG test, and he did not do so.
Mr. Porter, get yourself in to see me as soon as possible. You have no idea how close you came to spending several days in the Washington County Jail. Come in to see me as soon as possible. Thank you, Your Honor.
Thank you. Court does call the case of the People versus Stephanie Julian.
Caitlin Kirby on behalf of the people.
What do I need to do? Can you guys hear me?
Yes.
Yes, I can hear you, ma'am.
Okay.
I believe this is the public defender case, is it not? Or did we
It's
not
an arraignment,
adjourn?
Your Honor.
Right, we adjourned it for, okay. All right, Ms. Julian?
Yes.
All right, you are before the court on a 2-count complaint. Again, count 1 alleges that you did commit the offense of larceny less than $200. Do you understand the nature of that charge, ma'am?
Yes. But I
That
didn't
is a
steal any.
misdemeanor?
That was mine.
Hold on, I don't want you saying anything about the offense. I just need you to understand what you're charged with. Do you understand what you're charged with, ma'am?
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, then that would become the maximum fine. You understand that, ma'am?
Yes.
Count 2 on that complaint, that it alleges that at that same time and at that same location, that you did commit the offense of malicious destruction of personal property less than $200. You understand that charge, ma'am?
Yes.
That is also a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would, or property destroyed, that would become the maximum fine. You understand that, ma'am?
Yes.
All right. The first question that I have for you, ma'am, is do you wish to be represented by an attorney?
No. Can I ask you a question real quick? Was I supposed to swear?
Well, what are you going to ask me, ma'am?
Oh, no. I thought I had to swear in before you started. That's all I'm asking.
No, you don't have to swear in.
Okay.
All right. You don't want to be represented by an attorney, ma'am?
No.
Okay. What do you intend upon doing in this case?
What do you mean?
Pardon?
I'm gonna take what I got. I mean, the thing on his porch was not his.
Hold on, ma'am. I'm going to stop you.
Okay.
Right to be you. Anything you say to me or say at this proceeding can be used against you in this offense.
Okay.
And so I don't want you saying anything that might prejudice your case or any defenses you have. You understand that, ma'am?
Yes, I do.
All right. Now, ma'am, I'm going to ask you again, do you want to be represented by an attorney to, at least to help get you through this process, explain the process to you?
No.
Okay, so then, ma'am, what are you going to do on this case?
I'm going to tell you what happened because.
No. All right. That's not how the process works. All right. Are you telling me you want to plead guilty to these offenses?
I mean, the thing is, it's not.
Well, hold on. I don't want you saying anything about it. I asked a question. Do you want to plead guilty to these offenses? Is that what you're telling me?
Yes, I did. He has it on camera. Yes.
What? Okay. Ma'am, I get the sense that you don't understand exactly what you're doing.
No, I don't.
All right. So if you don't understand what you're doing, why wouldn't you want an attorney to help you through this?
Well,
to
okay.
explain all the process, go through and make sure all of your rights are protected. Why would you not want that to happen?
Okay, then I will.
Okay, so I'll ask you again. Do you wish to be represented by an attorney on this case?
Yes.
Thank you. This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Julian. We will waive any further reading, stand mute to those charges, and we'd request another pretrial date.
Okay, I'm confused. Why?
Okay, hold on, Miss Julian. Just hold on a moment, okay? We'll get you through some of that confusion. Defendant having waived formal reading, standing mute, court will enter a not guilty plea on her behalf at this time. I will, because I think there's going to be some extensive explanation. Pretrial in this matter will be adjourned then to November 1st, 2023 at 9 a.m. All right.
Can I ask a question?
Go ahead,
I'm
ma'am.
asking if I can. Is David or the cop here?
Okay, they would not be required to be here at this time, ma'am.
Well, the paperwork that I had said that it would be dropped if neither one of them showed up.
Miss Julian, I'll
Okay,
give you
okay.
a call and explain everything to you
Okay.
after today.
Okay, you got my number and everything?
Bond will be set in the amount of a $5,000 personal recognizance bond. I'm going to order standard conditions, including no assaultive behavior or possession of any weapons or firearms. There's to be no use of alcohol, recreational marijuana, or any illegal drug. I'm going to also order. Okay, I almost hate to ask, but I have to ask. Who is David Julian?
He's my brother.
Okay. At this time, do you need to have or think that you need to have contact with David?
No, we've tried and his wife tells him he can't talk to me.
Okay. So here's what I'm going to do, ma'am. I'm going to indicate there's to be no contact with David Julian.
Okay.
All right. Anything else, counsel?
Nothing further, Your Honor. Thank you.
All righty. Thank you. Miss Julian, make sure to talk to your attorney. It'll all become clearer for you, okay?
Yep.
Okay. Thank you, ma'am.
Thank you.
Case of Superior Township versus Manal.
Good morning, Your Honor. Jamil Williams for Superior Township.
Good morning, sir.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Manigault. Ms. Manigault, could you please state your name?
Yes, Janelle Renee Manigault.
Thank you.
All right. At great fear and trepidation, where are we?
Well, I haven't took the test yet, but some things had came up personally that I need to take care of first. And I was just wondering if I could just go ahead and pay the fee.
Yeah, I'm severely out of time on this case. So.
No problem. And I appreciate you being patient with me, honestly.
Ms. Manigault, this was beyond patient.
Oh, I know.
I
know. Trust me, I know. I've been getting flack from my family. I'm hearing it now, right now from them. And my sister's watching us live.
Okay.
Yes. So.
Well, Ms. Manigault, I was hoping that we could get you through this and
I
not kill any cones or do anything like that. But I don't think anybody can fault us for the effort.
Oh, thank you.
And one day, you will learn how to not kill cones in parallel park. All right.
Thank you.
So what are we doing then on this case today?
Well, Your Honor, seeing that there's nothing really holding her license, she's got everything else done except for passing the test. The people are satisfied with their progress, so we'll just move to dismiss.
Wow.
And we obviously have no objection to that. She's tried very hard for a very long time.
And my sister has recorded, so I don't know.
Mr. Williams, thank you for that. I think it's the right call in this, and sooner or later she'll be able to learn how to turn that wheel in 2 directions, get into a space. But Ms. Manigault, if you're ever like in Washtenaw County driving around and need to parallel park, do not come near me.
Okay.
Okay, just do me that. Case is dismissed. Thank you.
Thank you.
Thank you so much.
Thank you so much. Thank you, Judge.
Yeah.
Thank you all.
Take care.